The October 9th, 2025 meeting of the Santa Monica Rent Control Board is called to order. Would the secretary please take the roll?
Yes. Commissioner Ambrose is absent. Commissioner Dudek,
Present.
Commissioner Leslie,
Here.
Vice Chair Ivanov,
Here.
Chair Gonska.
Here. And would everyone please join me in the salute to our flag? I pledge allegiance to the
Flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
One note is on an agenda item tonight is that our legislative lobbyist, Brian Augusta, is unable to join us this evening. So item 12B will be postponed to our next regular meeting, November 13th. Item 5, if commissioners have had the opportunity to review the minutes from our last meeting, September 11th, may I have a motion for their approval?
I move that we approve the minutes.
I second it.
All right, may we have a roll call vote, please?
Yes. Commissioner Dudek,
Yes.
Commissioner Leslie,
Yes.
Vice Chair Ivanov,
Yes.
Chair Gonska.
Yes. Tonight, we do not have any special agenda items, so we will move on to item 7, public comment. I don't have any speaker slips for public comment, but this is the time when the public can address the board on matters that are not included in tonight's agenda, but within our subject matter jurisdiction. So if there's anyone here that would like to speak to the board, you can approach the secretary now. Otherwise, we'll move on to the next agenda item. All right. So item 10, jurisdictional items. 10A is an exemption for 2524 Montana Avenue. A new construction exemption application. May we have a staff report, please?
Good evening, Commissioners. Kelly McReynolds owns this property with her parents, who are now deceased, and the property originally had 2 units on it when the rent control law was enacted. In the mid-'80s, they built a 3rd unit on the property, and that unit, because it is built after the enactment of the rent control law and is not otherwise eligible, is not otherwise subject to the rent control law because of an Ellis Act requirement or because of a removal permit, it is eligible to be exempt as new construction. And for that reason, staff recommends that the board approve the exemption application and adopt the proposed findings of fact and conclusions of law.
Okay, thank you. Does any commissioner have any questions about the staff report? Okay. And we don't have any representatives here for this case, I don't believe. Does any commissioner wish to begin deliberation or to make a motion? Commissioner Leslie?
Go for it.
Me, or you?
Go for it.
I make a motion that we accept the report as stated.
I'll second that.
Okay, we have a motion and a second. May we have a roll call vote, please?
Yes. Commissioner Dudek,
Yes.
Commissioner Leslie,
Yes.
Vice Chair Ivanov,
Yes.
Chair Gonska.
Yes.
Okay.
Okay, next up we have, I believe we have 4 similar petitions for owner occupancy exemptions. So I don't know if there's any interest in commissioners to address all of these together, or if not, that's fine. If there are any specific questions about an individual case or any concerns that are specific to one or another. But otherwise, I would suggest that we can consider all four of them together.
Unless anyone has any questions, I would move that we adopt the findings of fact and conclusions of law on all four of these items simultaneously, 10A2 through 10A5.
I second that motion.
Okay, thank you. So we have a motion from Vice Chair Ivanov, seconded by Commissioner Leslie. And may we have a roll call vote, please?
Yes. Commissioner Dudek,
Yes, agree.
Commissioner Leslie,
Yes.
Vice Chair Ivanov,
Yes.
and Chair Gonska.
Yes. Okay, so moving on to item 10B1. This is an appeal of the decrease case at 1531 10th Street, Unit B. May we have a staff report, please?
Yes, Commissioners, this was a rent decrease petition filed by, forgive me if I'm mispronouncing the name, but I believe it's Shaheen Khazei, who filed a rent decrease petition based on reduction of management services. The hearing officer denied his petition, and he has appealed it. As detailed in the staff report, the issue here is that a reduction in management services requires the petitioner to prove management services at a certain level when the tenancy started and how those services have declined. And as detailed in the staff report, despite repeated opportunities to do so, Mr. Khazei didn't provide any evidence as to the level of management services at the outset of his tenancy, so there was no way to determine if there was any reduction in the management services. Moreover, to the extent that there was evidence in this case, the main concern seemed to have been a noise from the neighbor, who was an elderly woman who uses a walker, and that seems to be a significant part of what the noise complaint. The management actually put in carpeting to try to address that. And as I said, there was no evidence of a reduction, and there was no evidence even at the level of the services at the outset of the tenancy. So the hearing officer's decision to deny the petition is reasonably supported by the record. Also, as detailed in the staff report, the hearing officer didn't exclude evidence that was properly excluded evidence that was not relevant to the petition being one of reduction of management services, nor is there anything in the record that shows that Mr. Khazei's claim that the hearing officer denied him a fair hearing is supported. And finally, there was a suggestion that the board should grant decreases because of damages that he had suffered, but the board does not have the authority to award a rent decrease to compensate for alleged physical, emotional, or financial damages. Those have to be brought in a civil action in a suit. The board doesn't have authority over that. For those reasons, staff recommends the board affirm the decision and its findings of fact and conclusions of law.
Thank you. We do have the tenant here who would like to address the board. Before we do that, do any commissioners have questions about the staff report for staff? No. Okay. I do have a speaker request from Mr. Khazei. So if you'd like to step to the podium here, you'll have up to 5 minutes to address the board if you'd like to take it. So you can begin when you're ready. Oh, just before you begin, just want to reiterate that we can only consider information that was part of the case and part of the appeal. So please don't bring any new information here tonight.
Understood, absolutely. All right, good afternoon, and thank you all for having me today. I appreciate the opportunity to speak before the board. I'd firstly like to start off with 5 main points today, so I'm going to directly respond to these 5 points. Mr. Khazei provided no evidence to the level of management services at the outset of his tenancy, so in other words, a baseline was never established. I moved in on February 15 of 2024 and had no issues or complaints for over 4 months. My first written complaint was not until June 18 of 2024. So this period from February 15 through June 18 of 2024 constitutes the de facto baseline for management services. I think this is probably a point that wasn't made clear, and maybe that was my mistake of not establishing that baseline. But during this 4-month span, no management complaints were raised, no unresolved disturbances were documented, and management fulfilled its implied duties without intervention. In both legal and engineering contexts, a sustained period of non-issue establishes a measurable service standard or a steady safety concern, which then can be measured. So the significant decline in responsiveness following this baseline period demonstrates a clear reduction in services. The record shows a clear pattern of neglect and inaction by property management over a 16-month period, failure to intervene in ongoing disturbances, ignoring police and medical reports, not resolving, having no keys or access to my home for multiple months, offering no meaningful remedy despite documented harm. Point number 2, I want to make it very clear to the board that I am in no way seeking emotional or physical damages. I'm very much so aware that that is a matter for the civil court. I included police reports, medical documentation, and communications logs not to seek emotional or physical damages, but to demonstrate the severity and the continuity of the decrease in management services. These records show a clear and ongoing decline from the de facto baseline of services established at the start of my tenancy. They support my claim that management services were materially reduced and that the impact was not isolated, but sustained over a long period of time and serious. Hey, Vanessa, the police are here. 1 week later, hey, Vanessa, the police are here. Again, no reply. 1 week later, hey, Vanessa, you get the point. My request is based solely on reduced management services under RCCA Section 1801D and violations of Civil Code Section 1941.1. Medical information was submitted only to demonstrate the continuity and severity of the management's neglect, not as a damage claim. Point number 3 is he also complained about management failing to ask the gardeners about his keys. This was not a complaint, but a security violation. Management claimed that they asked the landscapers if they found the keys, as I suspected that they may have found them because I left them outside during the 5 minutes when I went inside, and that's when the landscapers came. So I suspected that they may have picked it up because they may have thought that it was lost. This was untruthful. I submitted their signed statement proving that they were never asked by Vanessa Palma, although she did claim that she did ask. So this directly contradicts Vanessa Palma's sworn statement. Instead of getting me keys when I was locked out of my home for 2 months, property management decided to cancel the request in the portal. I then remained locked out of my home until someone with a large amount of authority in the city of Santa Monica demanded Vanessa Palma to provide me with a new set of keys. And for those 2 months, I was locked out of my home. I did not have access to my home. I want to make that very clear. Point number 4, noise alone is not a basis for a rent decrease, and I could not agree more. My petition is based on reduction in management services, specifically management's failure to respond to safety and habitability concerns, secure the unit, and address the tenant distress. I'm running out of time. I guess I'll just say that this measurable decline from prior services level is clear proof of reduced management services under Santa Monica Rent Control Section 1801D and Board Regulation 3301H3. I'm running out of time. Guys, my mom's here from across the country. I've suffered so much. I've proven that there was a clear decline in management services over a 16-month period.
You can finish your thought if you'd like to.
Maybe move to another unit that was available? Yes, there were many available. Was it maybe feasible to break my lease? Was anything ever suggested by management on how to solve this issue? Or did I, as the tenant, have to come up with all feasible solutions? But I will say management did tell me something. Vanessa Palma told me directly, I'm not your therapist. figure it out, then hung up on me, blocked my number, and refused to let me break my lease, even after I reported the severe health impacts and submitted medical and police evidence. Both my medical doctor and my psychiatrist, who prescribes me a ton of medication due to these issues, have, with a reasonable degree of medical certainty, told me to get out of that unit because they are not going to fix it. So I'm just going to leave it at that. Every day in my home became a prison, and this issue is still not resolved.
Thank you for being here tonight and for speaking with us. We appreciate it. I don't believe we have a representative from the landlord here tonight. Is that correct? Okay. Do any commissioners wish to begin deliberation on this? Vice Chair Ivanov?
So one question that I have for staff is for a petition under Board Regulation 4200 F10 for reduction of management services, is the responsiveness of a landlord or the lack thereof, is that a criteria or a factor that can be used in the analysis of whether management services have been reduced or not?
I mean, it's possible, but there would have to be some evidence of a baseline of responsiveness so that there would be something to compare it to. And I think, as the staff report and the hearing officer's decision points out, there was no baseline of a level of services on that issue to establish any type of comparison.
So if there was, like, let's say in the evidentiary record, there was a bunch of emails from early on in the tenancy indicating responsiveness, and then when a situation like this happened, there were emails that went that were not responded to. Would that be something that?
It's hard to judge on a hypothetical like that. It all depends on the facts, and again, it's so fact intensive. But I think here the point is that there was no baseline established for the type of services.
Okay, thank you.
So, yeah, my reading of this appeal is really that there are several things that were brought up by the tenant that we just don't have the authority to issue a decrease for. So excluding each of those items, really, I think this comes down to considering if there are any errors made in the judgment around the decrease of management services. And unfortunately, my reading of this case and the staff report is that what the staff report says, which is that there wasn't a baseline established. So I think, as the tenant mentioned in his comments, there are potentially other remedies for some of these things in other forums. But unfortunately, in terms of what's here before us tonight, I don't see any error made by the hearing officer. So I would vote tonight to affirm the hearing officer's decision. But any other comments, or does any commissioner wish to make a motion? I'm sorry, we've already given you the opportunity to speak, so that's. Thank you. No, it's okay. We just have to follow our regulations here. Do we have any other comments or a motion? Commissioner Leslie?
Due to the lack of jurisdiction that we have over this case, we have no other choice but to affirm the decision and findings of fact and conclusions of law. That's my movement.
Okay, do we have a second on that?
I'll second.
Okay, we have a motion from Commissioner Leslie and a second from Vice Chair Ivanov. Can we have a roll call vote, please?
Yes, Commissioner Dudek,
Yes.
Commissioner Leslie,
Yes.
Vice Chair Ivanov,
Yes.
Chair Gonska.
Yes. Okay, next on the agenda is item 10B2, which is a decrease petition. It's an appeal of a decrease case at 2312 3rd Street, Unit B. May we have a staff report, please?
Yes, Commissioners, Dr. Catherine Smith is the tenant who filed a rent decrease petition here for maintenance conditions and reductions of housing services, and the hearing officer granted her decreases totaling $198. and the landlord, Mr. Besser, appealed the decision. As you know, this is a case where you act as an appellate body, and so if substantial evidence supports the decision, then you should affirm it. And in this case, as detailed in the staff report, there was substantial evidence for the decreases that were granted for termites, for the damaged wall that was not completely repaired, for the incomplete repair to the damaged hardwood floor, the fact that there was a deteriorated fence on the property, and that the parking lot surface was also deteriorated. Substantial evidence supports the decreases for all of those conditions. Mr. Besser also in his appeal mentioned things that seem to have occurred after the hearing officer closed the record, and those are not a basis to reverse the decision. They may be a basis for compliance, and staff has informed Mr. Besser of his right to ask for compliance, and I believe that he has begun that process. Nonetheless, this appeal is before you. Because substantial evidence supports the hearing officer's decision, staff recommends that you affirm it and its findings of fact and conclusions of law.
Thank you. And I do not believe we have representatives for the landlord here or the tenant tonight. So does any commissioner have questions about the staff report? Vice Chair Ivanov?
If Mr. Besser has started the compliance process, is the appeal now moot? Is there even anything to vote on, or?
Well, we spoke with him and asked him if he wanted to withdraw it. He seemed to believe that he had a point to make with the appeal, and so that's why it continues.
Any other questions? Any deliberation?
I noticed that the tenant was existing in the unit when he purchased the property. She came in 2016, he purchased it in 2018. That has probably no relevance, but I thought it was interesting. There's a sliding scale here in terms of what the adjustments would be. And while he did make some efforts, evidently, to improve some of these things, they weren't completely improved. And the hearing officer, gave decreases on the lower side, I noticed, versus the higher side. And we have to just go with the evidence, I think. And I'd like to make a motion that we accept this report and deny the appeal.
Do we have a second?
I'll second that.
Okay, we have a motion from Commissioner Dudek and a second from Vice Chair Ivanov. Can we have a roll call vote, please?
Yes, Commissioner Dudek,
Yes.
Commissioner Leslie,
Yes.
Vice Chair Ivanov,
Yes.
Chair Gonska.
Yes.
Okay.
Okay, moving along to item 11A. It's a consideration of a proposed amendment to Regulation 3035. May we have a staff report, please?
Yes, thank you, Chair. Good evening, Vice Chair, Commissioners. Before you tonight is a proposed revision to Regulation 3035, which governs the annual general adjustments that are specified in the charter. As you know, the charter sets the formula for the amount that the landlords can increase the rent for an existing tenancy. And the maximum allowable rent increases each year during a tenancy, whether or not the landlord has actually taken that rent increase. So if a landlord has not imposed prior year's general adjustments, that landlord can take those increases in subsequent years to bring that rent up to the maximum allowable rent. Right now, currently in the regulations, there's no limit on the amount that the landlord can increase the rent in a given year to catch up to the MAR. So this regulation will set a 10% limit annually for those landlords who are trying to increase the rent to the MAR. I'm available for any questions.
I have a couple of questions I'll start out with. My first question is, obviously, we've discussed before, and I think we're all aware of state law that that allows for only a maximum of 5% plus CPI up to a max of 10 as a statewide law. And so my question is really how, I don't know if we ever were really clear, or if there is any case law or any other way to be clear about how that impacts this potential, like this potential situation where somebody here has more than 10% of banked GAs. Is this really just because we don't have a clear answer on how the state law applies, or do we know that the state law would still allow them to do more than 10%, and that's why we need this?
Right. Our interpretation of the rent control law is such that because these are increases that have already been quote unquote earned, these are banked increases. So the state law that applies to non-controlled units would not apply in these situations to controlled units, because even though these rent increases have not been taken in prior years, they're still already earned. So we don't look at those as an annual increase such on the non-controlled units that the state law applies to, if that makes sense.
Yes, it does. Okay. And then also, I think you mentioned also in the staff report, it states that the general adjustments are, according to our regulations, can only be made on an annual basis. Does that mean that under this proposed amendment and also the existing regulation, that regardless of how much of the banked GAs are passed along, that they can only be done at like September 1st, for example, or can they be done when the new MAR would go into effect, or could they be done at any point throughout the year?
That's a great question. So I think the idea of the regulation is to allow a landlord to take up to a 10% increase in any given 12-month period. So in other words, September 1st, if they were to apply the annual general adjustment that applies to all units, let's say it's 2%, then in 6 months or whatever time period they want, if for example, they still have another 15% increase available to them to catch up to the MAR, they would only be able to impose another 8% increase in that 12-month period, because they'd already taken that 2% on September 1st.
Okay, so in theory, though, they could come to an agreement or just decide to, with the tenant to, say they have 10%, that they could roll that out 2% per month for 5 months. That would be allowable,
Yes,
as an example?
yes.
Okay. Or they could do it all at once.
They could do it all at once, right, as
And
long
I-
as it's no more than 10%.
Gotcha. And our existing regulation states that there's a 30-day notice requirement for that, right? We don't need to do anything additional here with this amendment.
That's right. So that's governed by state law, so the notice requirements wouldn't change.
Okay. Okay. Those are all of my questions. Thank you. In the queue here, Vice Chair Ivanov.
Just to clarify, specifically like how we arrived at the 10% figure, is that guidance from state law? Or like, why are we specifically at 10 and not like 12 or 8 or? Yeah.
So a couple of reasons. It's to align both with local law and state law. So, and also the anti-price gouging law. The municipal code, the city attorney's office has recently enacted a municipal code section that provides that any increases greater than 10% that result in a tenant's leaving the unit, that requires the landlord to provide relocation fees. So given that benchmark and also the benchmark from state law, that feels like a reasonable alignment with both of those laws.
Great.
Commissioner Leslie.
Thank you. This is more so in alignment with like our POD program, so how we protect our seniors in our communities that have been here for 20 to 40 years. And say like an old landlord does not raise the rent for like good 20 years. We have tenants that are being almost put out of their homes by a 20-year rate increase all at once, anywhere from $1,000 to $2,000. So I thank you for this, because what we're trying to do is just keep people in their homes. It's enough displacement going on right about now. Thank you.
Commissioner Dudek, before you begin, do you have questions about the staff report, or do you just have general comments about?
I know I have a question
Okay.
for
Go for it.
council. Yes, I'm would like a little more clarification on under what circumstances and the whys and wherefores in terms of a landlord requesting this in the first place. I mean, why, it's not commonly done, I don't think, but when it, why would they do it? Under what circumstances does it usually occur, in other words?
So, for example, if there's a new owner, if you have a longtime owner who has long-term tenants and they just haven't raised the rent during those tenancies, and then if a new owner takes over, for example, then they might be looking at a MAR that's significantly higher than what the tenants are paying. So a new owner might want to catch up to the MAR. And right now, there's no limit on how much they can increase the rent at all at once.
No, I understand that, but I do know, I had heard of a case where the landlord just didn't want to raise the rent for people. You know,
Yeah, there's
then-
no
and then
requirement
somebody
to
else
do
bought
that.
it,
Sure.
And then suddenly the rent was $600 more a month, and she was on the verge of,
Right. So that's what this is for, to limit the,
oh no, I agree with that. I was just wondering why landlords, is it mostly because they just want to be benevolent, or, you know?
oh, I don't know. I
Yeah,
couldn't tell you.
Reasons, but they can just do it.
Yeah,
Does there have to be a cause? There does not have to be a cause. Okay, thank you.
are you asking a cause to decide not to raise the
Yeah,
rent?
exactly.
Yeah, I mean, there's all kinds of reasons why they may choose not to. They could simply be not paying attention and didn't realize they could. They could also, I know of many tenants, because of the market conditions over the past few years, with COVID and coming out of COVID and then inflation and then
Right.
just with general market conditions, sometimes for relatively new tenants who are paying very high rents, if the market declines, a landlord may fear that if they raise the rent on an existing tenant, that tenant may decide to move out and go find something on the open market that's actually less than what they're currently paying. So they may decide not to increase the rent, even though they're legally allowed to, just because they don't want to lose the tenant. That's one example, but there could be many other
Heard of
circumstances.
a couple of landlords who they didn't want anyone to move, so,
Sure.
and they didn't, so they just kept it. But then, if they sell this can help, I guess.
Yeah, I mean, if they sell or if their financial situation changes, or, I mean, they have the legal ability to raise it up to the MAR. So this would just help to make sure that somebody isn't getting a massive increase in those cases. Okay, if there aren't any other questions about the staff report, we'll open the public hearing. And do we have any speakers on this item from the public? No, we do not. Okay. So we will close the public hearing. Is there any, does any commissioner wish to begin deliberation or make a motion on this?
I'll make a motion that I'll make a motion that we accept this, and I vote. And is there a second?
Do we need to read the
The motion?
motion? Yeah, maybe under the recommendation on the staff report, there's
Okay.
language there that you could,
Chair, are you closing the
For the
public?
first,
I did
Hearing.
close it, yeah.
Okay,
Yeah.
and then yes.
under here where it says for the reasons? For the reasons stated, staff recommends that the board adopt Regulation 3035F, limiting the imposition of banked rent increases to no more than 10% of the monthly rent in any 12-month period as set forth in Attachment A.
So is your motion then to adopt what the staff is recommending, which you just read?
Yes.
Okay,
And I
thank
think
you.
it's valuable.
And do we have a second on that? Commissioner Leslie seconded. Motion by Commissioner Dudek, seconded by Commissioner Leslie. And may we have a roll call vote, please?
Yes. Commissioner Dudek,
Yes.
Commissioner Leslie,
Yes.
Vice Chair Ivanov,
Yes.
Chair Gonska.
Yes.
Motion carries.
Okay, next up, agenda item 12, administrative items. 12A is a report on the progress of small claims cases to recover outstanding registration fees. And we have Rebecca Sherman here to address the board. So please, when you're ready.
Good evening, Commissioners. It's a pleasure to be with you tonight to give you a very short report on the agency's progress in recovering past due registration fees. The agency has been focusing so far primarily on properties that have fallen behind 3 years or more. And as we clear those cases, we will begin to focus on more recent lapses until we get more caught up. But we've had great success through the filing of small claims and limited civil cases. We have successfully settled the majority of the cases, and a few have gone to trial in which we obtain judgment or we obtain default judgments. And this has not been a solo effort. We've had great help from our information analysts, Karen Evans and Rose Patel, who represent the agency at the small claims proceedings. And our information coordinators, Dennis Arue and Antonio Vargas, are also in training following the lead of Karen and Rose so that they're prepared to represent the agency in future matters in small claims. I did submit a brief written staff report that you should have in your packet with a table that summarizes the status, and both with an update from last year's cases and the new cases this year. I just wanted to highlight a couple of things in the table in case it's, just to make sure you can follow. On the first page of the table, the top 4 bars in blue are, that's what was reported to you last October regarding the 2024 cases. And then the bottom 4 bars represented with the yellow and white, these show what the status is of the then pending matters. So you can see on line 3 of the table, there were 5 pending matters when it was reported to you last year. Those 5 cases are represented in the lower portion of the table. 3 of those cases were settled, and you'll see a footnote next to the 0 in the pending column. 2 cases were dismissed for procedural reasons. So now all of the small claims cases that were filed in 2024 have been resolved. The 9 cases that were pending in limited civil court from the 2024 cases are represented on the next to last row on the table. You can see that 5 of those cases have been settled and 2 remain pending. There's a motion for summary judgment pending and a default judgment pending on those 2 cases. And then on the second page of the table, you can see the status of our 2025 filed cases. 11 were resolved prior to filing suit after demand letters were sent. And these figures can also be updated right now because we did have one other small claims case settle. So the settlement column should now be 9 and the pending column is 5. And those cases are proceeding. So we have the new total from the 2024 cases is $113,133.52, and the amount collected so far in 2025 is $45,216.03. Also in the process of this effort, the agency has also been able to educate owners about the application of the rent control law. A lot of the reasons why these cases fall so far behind are because of a misunderstanding of how the rent control law applies to certain properties. Sometimes owners have moved and haven't filed a change of mailing address with us. Sometimes there's a new owner that hasn't filed a new ownership registration form with us. So sometimes there are problems along those lines. Other times, we've been able to educate owners about the eligibility for owner occupancy exemptions or fee waivers based on owner occupancy, or the separately sold condo fee waiver, for example. And in those cases where those properties are eligible for those, staff has been able to assist them in filing those applications to bring the properties into compliance with the rent control law. We've also been able to update our records with new addresses for the property owners and new, whether they're new owners or owners who have moved. So it's been a successful effort. That concludes my report, and I welcome any questions.
Thank you very much. I really appreciate you bringing this back to us, because I think we're all aware that this was ongoing, and so it's always great to get updates, especially on the great progress you're making. So thank you for being here. Really, one question, only question I have. I guess there's two questions. One is, I was curious about, and maybe this is a question for other staff, but feel free to answer if you know. Are there any substantial costs to the agency to pursue these cases? Like, we obviously have great information here about the additional revenue that's been collected. Is there any cost associated with that?
Fortunately, the costs are very negligible because we are a public agency, so we are exempt from filing fees and things like that. So we're not incurring those costs. The main cost involved in these cases is through investigation, trying to find addresses for people, and also service. So we're usually able to recover the service costs, especially if the case goes to judgment. We get service costs in the judgment. And in many of these cases, the owners are paying penalties for late charges based on the past due fees. And so the amount that we recover for those penalties more than covers the service costs.
Great. Yeah, that was my second question was, obviously we know that there are some penalties for not paying registration fees, such as not being able to pass along the half of the registration fee to the tenant and other various things. But I was curious about if they're charged interest or additional fees because they're delinquent on this.
Just the the 4%, the 4% penalty that applies based on our rent control law applies per month when you're late on the registration fees. But in these cases where our main interest is in bringing the properties into compliance with the rent control law, so we often settle somewhere in between. The penalties can climb really, really fast. So that amount can be pretty high if it's applied, especially for a 3-year period. I will note that in court, we're limited to a 1-year collection of the penalties. So when it goes to judgment, you don't see exorbitant judgments based on the penalties that have accrued for the entire period of time. But fortunately, the effort has resulted in bringing in enough extra income to cover the costs that are associated with filing the cases.
That raised one other question that just came to mind. Are these sort of done, all the delinquent cases, were they sort of all done all at once essentially, or if not, what is the way that you prioritize which ones to file first or to try to settle first?
So far, this has been on kind of an annual cycle. So how I look at it is we're limited to a 3-year period by statute of limitations about how far we can go back to collect past due registration fees. So I prioritize the cases based on, for example, last year, anyone who is delinquent from 2021 forward, those were the cases that I prioritized so that we could not miss collecting for 2021 based on the statute of limitations. So we got those cases filed in 2024. This year's cases were focused on properties who were delinquent since 2022, and we'll continue moving forward along those lines. What is great about this project is that the further we go, the fewer cases there are because we're catching people up and not having these long years of delinquency. So next year's report, I'm anticipating I'll have fewer properties that have been delinquent for that period of time. Because there were so many when I began this project, that's why I kind of focused on this annual cycle. But what I'm finding with this year's cycle is that because there weren't as many cases, I should have sufficient time to then prioritize the larger buildings. My next step, if there's not a statute of limitations issue to be concerned about, my next concern is the buildings that have the larger number of units. So that's where my priority would be next.
Okay. So are there, it sounds like, and correct me if I'm wrong, that there are, there's sort of a backlog that you're working through. So we're working within that time frame of statute of limitations, but there are other cases, other delinquent landlords out there that we just haven't gotten around to yet because of bandwidth issues, essentially.
Correct. We're making good progress and we're getting quicker about it. The goal is to be in a position where we're catching those cases more quickly so that it doesn't get to such a lengthy delay.
Okay. All right, thank you. Commissioner Dudek, did you have questions?
Oh, no,
No, okay.
thank you.
Vice Chair Ivanov?
I just want to say thank you to you and your staff that are leading this effort. I mean, just the 2 years that you've been doing this, we've collected over $150,000 for the agency. That's obviously not an insignificant amount of money for purposes of our agency's budget. The only question that I had was for the cases that do end up going to trial and you obtain judgment on, is there a mechanism to also petition for attorney's fees as well in that situation, or?
No, not in these cases. we
Okay.
don't have that.
Okay. Thanks.
Commissioner Leslie?
So I had a quick question. When you read off 45,216.03, did that include the one that just settled?
Yes, it did, because the one that just settled didn't have a monetary value. It had to do with compliance with the rent control law. So the person was eligible for a fee waiver, and they submitted, not a fee waiver, an owner occupancy exemption.
Okay.
So they were eligible for that, and on that basis, we were willing to settle the matter based on the facts that were presented to us in that case.
Thank you. The only other thing I wanted to say is thank you. You've done an excellent job
Thank you very much.
over these past 2 years. This is extraordinary. Thank you.
Okay, I think that those are all of our questions. So again, thank you for being here. Very happy to receive these updates, and hopefully we can, whatever staff determines is a regular, appropriate cadence, I'd love to have updates again in the future.
Very good, thank you.
Okay, I think that concludes our agenda for tonight. So can I have a motion to adjourn the meeting to our next regular meeting of the Santa Monica Rent Control Board, which will be November 13th, 2025? Commissioner Leslie?
I'll make the motion that we adjourn tonight's meeting.
Do we have a second?
Second.
All in favor?
Aye.
Aye. The meeting is adjourned.